So students, in this new video, we will discuss about the topic tribunals. So, what is the main characteristic of tribunal, or how is it different from a normal court? Tribunals are the semi-judicial, or we can say it as quasi-judicial bodies to solve disputes. So, tribunals are semi-judicial or quasi-judicial bodies to solve disputes. Now, why it is termed as quasi-judicial bodies? Any idea? It is termed as quasi-judicial bodies because it consists of administrative officers as judges and they don't have any legal background. Like they may not have legally qualified, so they don't have any legal background. They are just administrative officers. But while they presided in tribunals, they act like judicial officers. Like they hear the matters, they cross-check the documents or the relevancy or credibility of the produced documents and settle the disputes between the parties. So we can say that tribunals are complementing the role of courts. Now, I'll tell you some other important points about tribunals. These tribunals were not in the original constitution. It was added later to our constitution, and that was through 42nd Amendment Act 1976. So initially, these tribunals were not in our constitution. Later, it added to our constitution through 42nd Amendment Act 1976. Now, you just keep in mind these articles. Okay, Article 323A and Article 323B. These two clauses were added through 42nd Amendment Act, and then this tribunal included into our constitution. So, what does this 323A says? Article 323A deals with administrative tribunals. So, Article 323A deals with administrative tribunals. Means it tells everything about tribunals established to deal with administrative matters. So, 323A is administrative tribunals, establishment of administrative tribunal. And what is 323B? Other jurisdictions or other matters excluding this administrative or administration. Now, there are mainly two important tribunals. That is CAT. First one is CAT, Central Administrative Tribunal, and the second one is SAT, State Administrative Tribunal. And both these CAT and SAT were set up through Administrative Tribunals Act 1985. So, there are mainly two important tribunals, CAT, Central Administrative Tribunal, and the second one is SAT, that is State Administrative Tribunal. And both these important tribunals were established or set up through which act? Yes, Administrative Tribunals Act 1985. Now we will discuss about the jurisdiction of tribunals. Jurisdiction means, what is jurisdiction means? Jurisdiction means what type of cases these tribunals can consider or can settle. So service disputes between the employees is a main matter of these tribunals. So tribunals mainly deals with service matters of employees. Once a tribunal pass an order in a dispute, that order is challengeable only to the divisional bench of respective high court. Clear? See, tribunal is a quasi-judicial body. It mainly deals with service matters of employees, and once a matter is settled or an order is passed in a matter, if the parties prefer to go for appeal, they can only go to respective states divisional bench of high court. Divisional bench means not single bench. More possibly there will be minimum 2 judges will be there at the division bench. So the applied authority of a tribunal is the division bench of respective high court. And another important point is both the parliament and state legislature can set up tribunals. So who can set up tribunals? Both the parliament and state legislatures. So we can say that tribunals mainly dealing with service matters, that are the disputes between the employees. What could be the other areas, or what could be the other matters normally tribunals deals with? They are like the very important matters will be related to taxation. So taxation matter will be decided by the tribunals. Then comes this foreign exchange and exports. Matters related or disputes related with the foreign exchange and exports also deals with some administrative tribunals. And labor disputes. Then land reforms law related matters, like if any parties have any dispute and the matter in or the question of law is something related with the land reform law, then that could be considered by tribunal. And the next matter is sealing on urban property. Sealing on urban property means if there is any matter related with the fair prices of property in an urban area, matters such disputes, the matters and all will be discussed by tribunals. Then comes the election disputes related with election. Then if we have any complaint about foodstuffs and essential goods, then rent matters and tenancy matters, these all matters will come under tribunals. So mainly tribunals deals with service matters between the employees. The other jurisdiction areas are taxation, foreign exchange and export, labor dispute, land reforms law, then sealing on property, then what? Rent and tenancy, then matters related to food and essential goods, then election disputes. These all are the other jurisdiction of tribunals. So we already discussed that this term tribunal were not in the original constitution. Later on, it added to our constitution through 42nd Amendment Act. And then comes the importance of Article 323A and 323B. These two clauses were added through 42nd Amendment Act. So now we will find out what are the differences between these Article 323A and 323B. So the very first one is 323A means they will discuss or settle the matters related with the service. So as per Article 323A, tribunals are mainly established or set up to discuss the service matters. And what about for 323B? Yes, of course, 323B will discuss the matters that comes under other jurisdiction, like we discussed just before, like taxation, fixing, sealing of government property, rent, taxation, rent, tenancy, food and food supply. Then what else? Taxation. These all matters will labor disputes. These all matters will be discussed by the tribunal set up under Article 323B. The other important of Article 323A is that a tribunal can establish as per Article 323A only by the Parliament. So, only the Parliament can establish or set up a tribunal through Article 323A. So, that means the service matters will be is the main function of tribunal. Okay, and both the state and the parliament, both the state legislature and the parliament can set up tribunals under Article 323B. So the other jurisdictional matters, the tribunals set up to deal with other jurisdictional matters can be established by the parliament or by the state legislature. But this administrative tribunals to deal with the service matters that comes under 323A, that can only set up by the Parliament. This is the main two differences between Article 323A and 323B, which were added through 42nd. So we already said that tribunals are supplementing the role of courts in adjudication. These tribunals are supplementing the role of courts in adjudication. How can we justify this statement? Well, let's see. Okay. The very first point is that the procedures following in these tribunals are very simple and flexible. There are no complicated process or something. The process is very simple and it is very flexible. And definitely this will result in the efficiency of the tribunals will improve. Then the other important point is that an ordinary person can directly appeal to tribunal. That is not in our normal court. But before the tribunals, an ordinary person can directly appear before. Okay, for these tribunals. And the main motto of tribunals is speedy and expensive justice to all. So the motto of tribunal is speedy and inexpensive justice to all. See, if the litigation is before a normal court, it is definite that a government will be a major party in that litigation, and we all know that the government matters will have its own legal. So, what would be the result? That litigation will stay in pending for a long term. But if the matter is before the tribunal, we can expect, since its motto is speedy and inexpensive justice to all, we can expect the matter to be settled in a short time. But can we say that the tribunals can replace the role of courts? We already discussed that the tribunals can supplement the role of courts, but can they replace the role of courts? No. The tribunals can never replace the role of courts. This has been ruled out by a 7-judge bench of our Supreme Court, and that was in the landmark case, that is L. Chandra Kumar versus Union of India. And in that landmark case, the apex court held that tribunals could never taken away the exclusive jurisdiction of the courts, and the decisions taken by these tribunals are subjected to scrutinize by the division bench of respective high courts. So, the students, it's a very important point. These tribunals are quasi-judicial or semi-judicial bodies. They can never replace the role of a normal court, but they can supplement the role of a court in adjudicate matters. And this statement is clearly um, held by a 7-judge bench of Supreme Court, and that was in this landmark case, L. Chandra Kumar versus Union. You students, you don't need to go into the facts of this case or something. You just have to mention this landmark case. That is, the case was L. Chandra Kumar versus Union of India, and in this case, it was the judgment was passed by a 7-judge bench, and the Supreme Court, and the statement of the court held that the verdict was something is that the tribunals could never plays the role of courts. They cannot take away the exclusive jurisdiction of the courts. Uh, at the same time, the apex court also added that the decision taken by the tribunals were subjected to scrutiny by the what? By the division bench of the respective courts. So before concluding this video, we will discuss some additional points like how many benches the CAT have all over India. This CAT, that is Central Administrative Tribunal, has over 19 benches and 19 circuit benches all over the India. So 19 benches and 19 circuit benches CAT has. And at the same time, what all matters will come under the jurisdiction of Administrative Tribunal Act 1985. Our central government has declared almost 215 organizations, including the Ministry and Department of Central Government, will come under the jurisdiction of Administrative Tribunals Act 1985. So, in total, around 215 organizations, including all ministries and departments of central government, will come under the jurisdiction of this Tribunals Act. And there is a principal bench of the Central Administrative Tribunal to deal with matters related with the government of National Capital Delhi. And normally in a tribunal, it consists of a chairman, a vice chairman, and members. So a tribunal consists of a chairman, vice chairman, and its members. And how do these members will be selected? These members will be selected both from the administrative area and judicial area. So the members will be both from administrative section and judicial section. Because if we choose these members that whom have had full experience from administrative as well judicial sectors, it will help the tribunal to deal with the matters in an expertise way, both judicially and administratively.